It's Jerry Mason, your Kickin lawyer here again. I appreciate those of you that watched the last video. This post is going to be about Miranda, the Miranda warning. It's more commonly known. We get calls all the time at the law office. When I was a cop, obviously I dealt with the issues of Miranda, and then of course now as a lawyer, it's a big issue that a lot of clients call in about. We have a lot of times, like for example, we'll have a client call in, and they'll be like, "He violated my rights. They didn't read me my rights. You know, I'm supposed to get my rights. I seen it on TV. They're supposed to read me my rights." And the majority of people can even quote what's commonly referred to as the Miranda warning. You have the right to remain silent. Anything you say can will be used against you, etc. So it's interesting that so many people know about it, but they don't really know a lot about it. They don't know like when it applies and whatnot. So I'm going to give you just a brief rundown of that. So Miranda was a Supreme Court case that came about in 1966, and obviously it came out of Arizona. The case is Miranda v. Arizona, and it was decided by the Supreme Court in '66. And it dealt with police interrogation of suspects and whether or not confessions were voluntary or not, or any admission, whether it was straight up a confession or some kind of other statement that would incriminate a suspect. And so basically in the Miranda case, this is another interesting point a lot of people don't know. It was actually a consolidation of 4 different cases. The Supreme Court does that sometimes when a case has a similar issue. And again, so like these cases were brought together. Miranda was the first case, so it's the named case in the unified cases. And it specifically dealt with whether the government is required to notify the arrested defendant of their Fifth Amendment constitutional right against self-incrimination before they question or interrogate the defendant. Now, in the Miranda case, Miranda was a guy named Ernesto Miranda. He was arrested originally for kidnapping and raping a victim, allegedly, of course. And, of course, they arrested him. He was interrogated for like 2 hours. He didn't speak very good English or even understand English. He did sign a waiver form, but the argument was that, he didn't have an attorney. He didn't understand what he was signing, and so thus through the exclusionary rule, the confession should be thrown out. And the confession was used against him. He was convicted. Went all the way up to the Supreme Court. The Supreme Court did rule that it was an unlawful acquisition of the confession, that his rights were violated. So it was knocked back down. In Miranda's specific case, what's interesting is he was actually retried without the confession, was still found guilty, was still convicted, and he ended up out. I think he was out for a few years, and then he ended up getting rearrested again for several other things through the course of several years. He ended up getting murdered in a bar fight in 1976. It was a guy with a knife come up and attacked him or whatever at the bar. And the ironic thing, though, is as that suspect was let out, he was read as Miranda Rights. So that's kind of ironic. But as far as the legality of when Miranda applies, so let's use an example. The police come up, stop you for running a stop sign or something, okay? And they come up, they start asking you questions. Where you been? What are you doing? Do you know why I stopped you? All this kind of stuff. And obviously some of those questions could solicit what most people consider an incriminating response. The police do have some exception, though, to do initial questioning. They can do questioning for investigative purposes. There's also a public safety exception. Let's say there's been a shooting, chasing somebody, they catch him, he doesn't have a gun, they start asking, hey, where's the gun, where's the gun? And the argument is, if he threw the gun, you don't want a child to walk by or something in the neighborhood and find the weapon, so that's a public safety exception. Basically, though, here's the takeaway you need to know from Miranda. So Miranda only applies in custodial interrogation. So what that means is, first, there has to be government action. Okay, so like a private citizen doesn't have to Mirandize another private citizen if they've taken action against that citizen somehow, if they do a citizen's arrest or whatnot. It has to be government action, okay? Also, the suspect or the defendant, they have to know that there's government action. So this comes up sometimes in like jail cases where they'll have a CI or something in the jail trying to solicit information from an inmate, or on the street when they have a confidential informant try to make some buy and they're wired and everything by the government. Is if the suspect doesn't know that they're a government agent, then there's not government action. So that first prong's not there. The second prong is, so one is government action. 2 is custody. there has to be actual custody. And this is where a lot of times you get into the real legality of it, and what attorneys argue in motions is whether or not they were in custody. In other words, if the officer has now exceeded their investigatory scope, if the suspect is not free to leave, there's a lot of elements that the court has given us guidance on to look at whether or not the suspect is in custody. Basically, the rule is if a reasonable person, that's the standard, the reasonable man, if a reasonable person feels like they are not free to leave, well, then it's arguable that they're in custody. There's other factors too, where they were questioned at, the number of officers present, all this kind of stuff. But you got to have government action, one, and then the second factor would be custody. They have to be in custody. So if you're standing on the side of a traffic stop, you technically are detained. It doesn't really rise to the level of custody yet. Now clearly if you're handcuffed in the back of a patrol car, there's clearly custody present at that point. And then there has to be questioning. And the questioning has to be of the type that would solicit an incriminating response. Okay? So if they're asking you your name, that's not considered by most people an incriminating question. I understand some people have warrants, but that doesn't mean, the general public doesn't. So, if they just ask a general question about what's your name, where you live, what's your date of birth, social security number, all that kind of stuff, that in and of itself is not questions that solicit an incriminating response. So if there's government action, if there's custody, and if there's questioning that would solicit an incriminating response, then Miranda applies and is applicable and must be given prior to any questioning. Okay, so that's your 3-prong test to determine if Miranda is essential. Now, what if they violate Miranda? We get this a lot of times. Again, our firm does a lot of 1983 litigation, that's civil rights litigation. So if people call in and they're like, he violated my rights, I'm get all this money. Well, on the criminal side, and given there could be some civil issues civilly that you could bring under the 1983 actions and other statutes, but on the criminal side, which is what I'm focusing on, the remedy is suppression of the evidence, and that's it. So, it's not like you get away free or they drop all the charges. They might, because if the confession's the main piece of evidence they have and they lose it because it was taken illegally, and it's suppressed, which means they can't use it at trial, then the prosecution might decide to drop the case. So that is the remedy for a violation of Miranda by the government, is suppression of the evidence. And obviously that doesn't just come about. Usually it's, attorneys have to do motions and whatnot, motions to suppress for this and that, and sometimes those are even argued, and it can turn on, nuances of the facts. So I hope this video has been informative to you. Again, I plan to weekly load some video that has hopefully some information, because remember this, you got to know your rights. That's important. And you need to know the real legality behind the rights. And I think knowledge is really power in a lot of ways. I've been on the other side when I was a police officer, and I think knowledge served me well there. And then now on this side as an attorney, obviously to help my clients, I need to have good knowledge. But what I find is a lot of times there's misinformation. People don't really research the issues. Maybe they watch other YouTube videos, I don't know, or they're just watching something on TV, CSI and whatnot. And so they get misinformation about the way the law actually applies to you. So anyway, I think that's important for you to know, is to have a grasp of your rights and really understand them. As always, you can contact us at the Huffman Law Firm. You can message me directly if you have any questions. What I've covered today, for the most part, is federal law, like constitutional law and rights. And so every state has some degree of protection. Some states give more protection in these areas than others on self-incrimination. So I'd urge you, if you have an issue with this, you need to locate a competent and licensed attorney in your specific jurisdiction. Because there are variations. And obviously, if you're dealing with government action and you're a defendant, you need a lawyer one way or the other. Again, you need to protect your rights. You need to know your rights. And, if somebody violates your rights, government or otherwise, you need to be prepared to fight. And so that's what I've tried to do the majority of my life. And I'd be glad to fight for you guys. If you need anything else, like I said, please give me a message. And if you like this information, please like it below and subscribe to the channel, because again, I think knowledge is power, and I'm hoping to give you guys some over the next several weeks. So hope you have a good day.